Thank you, Kathy. Good to be with you. Good to be with everyone else on the program. Again, we're grateful for the loyal audience we continue to have. Coming up on 2 years to the day when we started this, hard to believe in a lot of ways. It seems like 2 seconds have passed, and then sometimes it seems like 20 years. I can't decide which is which. Maybe it's both. We've got a great program once again today. I have 3 guests who are going to cover important and timely issues for you. We're going to talk about the New York State budget bill and what issues in that bill should be of concern and attention for employers here in New York. We're going to talk about a significant development when it comes to ERISA fiduciary obligations, and then also talk about some developments with respect to quarantine and isolation requirements here in New York. But before we do that, I want to just touch base, as I do at the start of my programs here, and give you a little bit of background on what we're seeing by way of COVID infection trends. I've got a few charts for you that I can show. If we move along, we'll see the first one. All right, so this is the national chart here. Again, we see both the significant increase that we've experienced as a country here in January, and the equally steep decline, which of course is good news on the cases, and that trend continues and doesn't show an indication of relenting. So that's good, and that's positive, of course. In terms of what we've seen in New York, we've continued to see positive trends, as the next slide will show here. Again, this is all from the Johns Hopkins Center, but here we see New York in the middle group here, having continued declines in the number of new cases, significant declines in the positivity rates. Again, we're at 4.5% right about now. Beginning middle January, we were up in the neighborhood of 22% in our positivity rates, and with a large volume of tests being performed too. We see some dispersion across the country. There's different methodologies in terms of how these positivity rates are determined. So it's not always an apples to apples comparison. You see Puerto Rico and New Jersey up there. And of course, this doesn't necessarily account for at-home tests too. So it could be, right, that rate in New York could even be lower than what we see here too. But many reasons to be encouraged, that's for sure. I also like to include information for your reference on hospitalizations and ICU use. You'll see on the next slide, I believe, which will be the ICU occupancy here in New York. And again, not national stats, but looking at New York stats, because in my experience, this has been a big driver on policy and turning on the faucet or lowering the faucet that Pete would talk about back when he gave these webinar programs in terms of the requirements that the state is implementing to help control the infection rates. Here again, we see the positive trend continue. We have only 76% of ICU beds occupied. The overwhelming majority of those ICU beds are being occupied by non-COVID patients, and again, a comparatively small percentage being occupied by patients with COVID. Again, not necessarily because of COVID, but patients with COVID. On the next slide, you see the overall inpatient figures here again. So this is casting a wider net. Once again, we see the occupancy in the mid to high 70s of these. We see a very small percentage of the currently occupied beds being occupied with patients with COVID. And we're also seeing, as we were with the ICU, a nice cushion there in terms of remaining beds. So hopefully that all bodes well for the future, continuing trends, and then as our state hopefully modifies policies accordingly. So on that front, there's been a couple developments that I wanted to just touch base on briefly. And neither of them, I don't have anything firm to report on either of them, but you will recall we've talked in the past about New York's so-called mask or vax mandate requirement. We've talked about the legal challenge that was filed down on Long Island, a state Supreme Court ruling that overturned that max or mandate requirement set by the State Department of Health, and then further litigation, which essentially put a stay on that lower court ruling and left the status quo in place, that being the vax or mask requirement across New York. And interestingly, there was a news report this morning indicating that the governor was likely to rescind that guidance when it comes to indoor operations and general requirements applicable to employers. That's actually set to expire, I believe, this week. And you'll see on the next slide, this you may have seen it already. There were some headlines that were set on this. Some question about whether schools will be included. What I read before the program today seemed to be that schools may not be included in this lessening of the restrictions for masking, the requirements for masking, but I guess we'll have to see on that. I believe that particular requirement isn't set to expire until later this month. So I guess stay tuned tomorrow for the news. We could see positive development on that front, giving employers more flexibility in terms of how they want to handle the masking issues. And of course, we'll cover that. I'll send a link out to our blog, the New York Labor and Employment Law Report, just shortly here so that you have that. If you're not subscribed to our blog, I would encourage you to do so. It's a great way for us to push out emerging content. We do it on a regular basis. So if there's anything between our webinar programs, you'll be able to catch it there too. The second development that I know at least I mentioned on my LinkedIn feed and that others may have noticed too is that New York had in place guidance relating to what I'm going to call the COVID paid sick leave, right? That's the sick leave where somebody is subject to a governmental isolation or quarantine order. And this guidance had been in effect since January of 2021. I call it the 3 bites at the apple guidance, where an employee could be eligible in theory for a second or third period of benefits, of paid leave benefits or protected leave under the law if they themselves test positive. And again, this guidance was published back in January of 2021 and has been listed on the Department of Labor's website since then. Just by chance, we happened to be cruising the website and noticed that they had removed that guidance. And in reaching out to various contacts that we have, we were advised that that was intentional and that the state was considering potentially a change to that guidance with respect to paid sick leave. Again, this is the COVID paid sick leave benefit. What that may entail is not clear at this time. I do know that we here and other trade groups certainly have heard from employers that the spike in positive cases coupled with the current isolation and quarantine requirements was really placing a burden. It was placing a burden and having a negative impact on productivity, certainly, and on related business issues with staff being out for extended periods and a higher volume of staff being out for extended periods. Couple that with the paid leave benefit, and this was constituting a very significant outlay of unreimbursable expenses for employers. And again, I don't know what we're going to see from the state here. It seemed there was some indications of a desire to try to be more accommodating to businesses recognizing some of the hardship that's being experienced. And again, businesses are all that we're working with and employers of all shapes and sizes are continuing to try to do the right thing and are doing the right thing by providing the paid leave to employees. But as a practical matter, there is this challenge when it comes to maintaining operations. And again, I think it goes back in a lot of ways to the isolation and quarantine requirements that are in place. Peter Wiltenberg's here. He's going to be talking about those a little bit later in our program. I did note that while the 3 bites at the apple guidance was removed from the usual spot in the Department of Labor's website, and that's the first, the top portion that you see here. And I'll send a link out to this in just a little bit once I turn it over to our next presenter. But in the FAQs relating to the COVID paid leave benefit, they still do reference the 3 bites at the apple, as I refer to it, level of benefit here. Now, that could just be an oversight that they forgot to remove that one piece of the FAQs. I don't want to read too much into it, but the takeaway I think for you all here is let's stay tuned on this issue. Again, if there's a development before next week, I'm sure we will push out guidance through our blog, through other social media resources so that you have that information as well. Stay tuned. Okay, so that's the latest on COVID. We wanted to have Stephanie Fedorkas join us today. Stephanie, as you know, is a regular presenter here. She's an associate who works in our labor department, works out of our Rochester and Syracuse offices. Stephanie is somebody who I work with and have the pleasure to work with very frequently, and also somebody who's done a tremendous job for the firm, staying on top of the many developing legal issues that we have here in New York for employers. Stephanie, to her credit, took the time to go through the voluminous budget bill here in New York, and as often is the case, she was able to find several provisions in that bill that would have a potential impact for employers, and she wanted to give everyone here an update on what some of these issues are so that you can keep your eye out for further developments. So with that, I'll turn it over to Stephanie and say thanks for joining us.
Thanks, Andy, for having me back on. It's a pleasure to be with you guys today. Thanks for joining us, and a pleasure to keep you all up to date. So we'll take a couple minutes to go through what the 2023 budget bill says. And I picked out a handful of those provisions that I think are directly labor and employment related to update you all today. So on January 18th, Governor Hochul announced a $216.3 billion budget proposal. Particularly what we're going to talk about today is the Education, Labor, and Family Assistance provisions, which is Article 7 legislation. So we'll take a few minutes to kind of piece through, again, it's about a handful of different changes or proposed amendments to either existing labor laws or other laws. The first that we'll talk about is a ban on non-compete and non-poach agreements. So the first provision is that it proposes this new section of the labor law that would be codified under Section 202M. And ultimately, it would do two things. It would prohibit non-compete agreements for any employee or prospective employee earning less than the median wage in New York State. Those are going to be defined as the covered employees or prospective covered employees in the law. Second, it would prohibit employers from seeking, requiring, or demanding or accepting a non-compete agreement from any employee earning above the median wage, so the non-covered employees, unless the agreement meets certain requirements limiting its application, which we'll go through briefly as well. This would generally apply to any private employer and explicitly excludes governmental agencies and would take effect 180 days after enactment of the law, or if this is passed. So non-compete agreement is defined in this proposed new 202M as an agreement or contract that prohibits, discourages, or otherwise restricts an employee from obtaining employment in any specified geographic area for a specific period of time or with any particular employer or in any particular industry. So I wanted to raise that definition for you, and then to break down again those two prohibitions. So first, the total prohibition on non-competes with employees or prospective employees who earn less than the median wage in New York State, and that's subject to change. So that is something that if this law passes, employers would need to be mindful of. If you have employees who may be subject to a non-compete agreement, or if that's something that you want or are interested in, that median wage may change. And the second is the limitation on permissible non-compete agreements. So those would apply to employees other than those covered employees, so employees who are earning more than that median wage in New York State. And it would prohibit employers from requiring or seeking, demanding, or accepting non-competes unless the following conditions are made. I'm not going to read every single bullet point on this list for you, but ultimately what this does, or what this proposed law would do, is limit what a permissible non-compete would be for all other private employees. And it has things in there such as not containing a term of more than 1 year after the employment is ended. It would need to be disclosed in a written offer of employment or in a written offer of a promotion at least 10 days before the effective date of that promotion or employment. It needs to not impose an undue hardship on the employee, but the law doesn't currently define what that undue hardship may be. It would need to be strictly limited to be no more expansive than required for the protection of the legitimate interest of the employer. So ultimately, broad non-competes would have to be either rewritten and make sure that all of these provisions are either included or addressed or comply with those requirements in order for it to be an enforceable non-compete. Again, only with respect to those non-covered employees. Interesting as well is that it could not require an employee to adjudicate outside of New York State for a claim arising in the state of New York. So those choice of law provisions. An employer would have to maintain that record or that agreement for more than 6 years from the end of the agreement. It could be voidable at the option of the employee if an employer cannot demonstrate continued willingness to employ the employee. And it can't deprive an employee of the substantive protections of New York law with respect to a controversy arising in the state of New York. So if any disputes arise under one of these agreements, you couldn't have a choice of law provision that would remove it from New York law. This would not apply to enforcement of covenants not to disclose trade secrets, employees covered under New York labor law section 202K, which applies to broadcast employees, presumably because that area or that section of the labor law includes its own limitations on non-competes with respect to those covered broadcast employees, and agreements between bona fide owners or partners of a business. A couple other notable provisions in this new section 202M that's proposed is that you would have to maintain a copy of any agreement that you would have, any of these non-competes contracts or agreements. It must be open for inspection, and copies must be promptly provided to the Commissioner of Labor upon request. Again, there's no definition to promptly, but it would have to be made available to the Commissioner of Labor upon request. Violations of this section of the labor law would include damages, attorney's fees and costs, and civil remedies for an employee who would allege a violation, and other penalties arising under New York labor law sections 218 and 219, which are also in the labor law, and we can discuss those in a couple slides as well. And we talked about that choice of law and those specifics regarding New York law applying in disputes arising of these with respect to these agreements. The second piece of this is a prohibition against no poach agreements. So it would also propose an amendment to General Business Law Section 340, adding new subsection 7. And it would prohibit an employer from entering into a restrictive employment agreement that would prohibit or restrict that employer's ability to solicit or hire another employer's current or former employees. So it would do two things. One, make it unlawful for an entity to enter into such restrictive employment agreement. And two, it would make it unlawful to enforce or threaten to enforce such a restrictive employment agreement. And that would also go into effect 180 days after enactment. So if this law is passed, or the budget bill is passed. Next, increased criminal penalties for wage theft was another section that is worth noting in the budget bill. It proposes to amend section 198A and section 213 of the New York labor law, and ultimately increase penalties for employers who willingly or who knowingly engage in wage theft. And I have a chart or a list of the different proposed changes of what those penalties would be, but they ultimately correspond with the specific amounts of wage theft per employee. It would become effective immediately upon enactment if it's passed. So currently, New York labor law section 198A, a first offense is a misdemeanor and can carry a fine of $500 to $20,000 or up to 1 year of imprisonment. And a second or subsequent offense within 6 years would constitute a felony, $500 to $20,000 fine, or up to 1 year and 1 day imprisonment, or both for each offense. And it should be noted that the section 198A it generally provides that anyone who violates a section of the New York labor law could be prosecuted for a misdemeanor, although we don't see that typically happen. The proposed amendment to New York labor law section 198A would increase these criminal penalties, and it becomes more specific as broken down in these bullets, again, based on how much the wages were owed either to a single employer for more than one employee. And restitution. A court could order restitution of wages in an amount of underpayment together with the amounts provided by New York Labor Law Section 218. In addition, it would propose to amend New York Labor Law Section 213. That law currently provides that any person who violates or does not comply with any provision of the labor law, as I mentioned, any rule, regulation, or lawful order of the Commissioner of Labor or the board, and the officers and agents of any corporation who knowingly permit the corporation to violate such provisions would be guilty of a misdemeanor. It would amend this section to increase the penalty or clarify that a first-time offense would constitute a Class A misdemeanor, and a subsequent second offense committed within 6 years of the date of conviction of the prior offense would be a Class E felony. And then our last section that I wanted to discuss, discrimination against victims of domestic violence. You may know that victims of domestic violence are a protected class under New York state law with respect to employment. The budget bill proposes to amend the section 296 of the executive law to expand these protections to all of the jurisdictional areas. So that would include public accommodations, private and publicly assisted housing, education, and credit. And that would become effective immediately upon enactment. So again, not a huge change for employers necessarily, but certainly broadening it to all of the other aspects of 296. And lastly, discrimination on the basis of citizenship and immigration status would also become its own protected class under the New York labor law or the New York human rights law. Notably, the Division of Human Rights practices to investigate or enforce these types of allegations of discrimination under national origin, which is a protected class currently under the New York human rights law. But this would ultimately further clarify that this is its own protected class. This would also become effective immediately upon enactment, so if the law is passed. I wanted to flag last on this immigration and citizenship status that it would define citizenship or immigration status as the citizenship of any person or the immigration status of any person who is not a citizen of the United States. However, nothing would preclude verification of citizenship or immigration status where that's required by law, or adverse action that's taken based on such verification would not be prohibited where that adverse action is required by law. So notably, if individuals have to have permission to work, if they are not, if they have a certain immigration status, so verification of that through your I-9, et cetera, that would still be permitted. That nothing in this human rights law would alter that. It's just further clarifying what is being done by the Division of Human Rights currently. So any action, if you don't hire someone or if you terminate someone because they didn't provide this verification as required by those federal laws, then that would not be unlawful under this change in the human rights law. So that's pretty much what I have for you. What's next? The New York State Constitution requires that the budget bill be approved by April 1st. So we will be monitoring for any changes in those proposals and certainly report back on that. So stay tuned.
Stephanie, thank you. Very helpful to get that overview. These are issues that in the past we've seen interest at the legislative level, certainly with respect to contracting the enforceability of restricted covenant agreements, non-competes, and the like. Again, with respect to the wage and hour developments, again, that is part and parcel with the clear trend that we've seen, which is really raising the stakes on those wage and hour compliance matters. So stay tuned, as Stephanie said. We'll report back if and when there's further developments on those issues. Again, just proposed at this point, but are noteworthy for sure. So next up, it's my pleasure to welcome Larry Fennell from our New Jersey and New York offices. Larry wanted to come forward today to talk to you about a pretty noteworthy development when it comes to fiduciary obligations and liability under ERISA and a recent case before the United States Supreme Court. So Larry, thanks for being with us today.
Thanks, Andy, and good afternoon, everyone. I'm going to be speaking to you today about the recent case that was decided by the U.S. Supreme Court, Hughes v. Northwestern University. If you can flip forward to the next slide. Yeah. The case involves participants in the Northwestern University retirement plans, both of which were 403B plans, defined contribution plans that operate in a similar fashion to a traditional 401k. The plan itself had, or at issue in this case were the fees being charged to participants under the plan, specifically in two categories. First, in investment services relating to the design and the maintenance of the particular investment options available under the plan. And secondly, the record keeping fees being charged, which are traditionally fees for tracking account balances, providing statements, and the like. The petitioners, the participants in this case, sued Northwestern University, the administrators of their plans, as well as their investment committee, arguing that they breached their fiduciary duty of prudence because they didn't monitor and control these record-keeping fees. They offered investments that had higher fees rather than similar performing fee funds with lower fees. And they offered over 400 funds to the participants, causing confusion and contributing to poor investment decision-making on behalf of the participants as a whole. Jumping forward here, the Seventh Circuit heard this case. It was heard at district court level, and the Seventh Circuit held that the plan satisfied its fiduciary duties because it offered a lot of different investments. And as a result, because it offered those, including the preferred options that the participants argued should have been the primary ones provided under the plan, that participants could have selected other investments. They could have avoided these fees and made a decision. So they ended up, denying the participants' claims in that action. The case got heard by the Supreme Court, and on review, they said that, well, that's not the case here. The Seventh Circuit was incorrect by focusing on the diverse menu of options that they offered to participants. And when looking at this case, offering a menu of investments is just one aspect of the duty of prudence that a plan has to its participants. They didn't address the fact that the plan fiduciaries need to continuously review the investment lineup, monitor fees, and also monitor record-keeping fees and expenses, and remove those investments that are imprudent or the record keepers that are overcharging or just overall not providing value services to the participants in a timely basis. Ultimately, it doesn't have to be immediately, but it must be within a regular, systematic review within a reasonable amount of time. Skipping forward to the next slide. The court focused on two aspects of the duty of prudence here, and they said, both on a context-specific inquiry, looking at the facts and circumstances that were prevailing at the time the fiduciary was acting to see if they acted prudently, and noting that there are difficult trade-offs here that fiduciaries need to make. They must consider, the potential, the various potential opportunities there, and determine which ones are best, and in light of the experience and expertise that the fiduciary has. So skipping forward here, ultimately, the court's decision, the court sent it back to the Seventh Circuit to reconsider the issues at hand to determine whether the plan acted prudently. So they didn't actually say necessarily that the acts are imprudent, but presumably, I think that decision is forthcoming. Some of the takeaways here, I think the key takeaway for any plan that's sponsoring a defined any sponsor that's offering a defined contribution plan to their employees is, regularly monitor that investment lineup. Look at the fees and expenses being charged. Look at the other options available. And if you feel an investment is an imprudent investment based upon, a regular review, then timely removing that investment, from that investment lineup. And the same goes for record keepers. Look at your record keepers. Decide, what services they're providing, what fees they're charging, and are the fees reasonable in light of the services being provided? There's no bright line rule on what constitutes a prudent decision. And the court didn't assist us at all in determining, and providing any bright line rules. But, it's always important to, regularly review, the all aspects of your plan, particularly any time a fee is being charged, determining whether that's a reasonable fee, evaluating competitors, looking at the different funds that are available, especially in this particular case, the argument being that there was an institutional fund available with lower fees that performed in a similar fashion. Can the plan gain access to that? Look at what peer plans are doing. Have you conducted an RFP on your record keepers of late? Have you looked at your investment policy statement? It's important to evaluate the policies, processes, and procedures that are in place for handling these actions, and then also ensuring that you're documenting these decisions. Again, these are just a few things that I'm mentioning now, but if you have any issues or concerns about your own plan and the plan investments or service providers that are receiving fees, particularly fees that are paid out of plan assets, please feel free to reach out. We'd be happy to discuss it further with you. I thank you very much for your time and have a great day.
Larry, thanks. Very helpful and useful information here. And just to echo your last point, I suspect there'll be some questions that we may get on this. And those are by nature going to be individualized and require a fact-sensitive analysis that's going to differ from entity to entity. So like Larry said, if you have a question with respect to compliance or any concerns, please feel free to reach out to him. His contact information will be included at the end of the presentation here, and we'll be happy to assist. All right, last but certainly not least, we have once again joining us, one of our regulars, Peter Wiltenberg. Peter works in our Buffalo office, and it's our pleasure to have him here today. The state quietly published some new guidance. I guess Peter will go into whatever depth's appropriate on the newness of this, but some new guidance on quarantine and isolation requirements here in New York. And so we wanted to spend a few minutes just to get you up to speed on the latest here. So Peter, thanks for being with us today.
Thanks, Andy, and good afternoon, everyone. So yes, as Andy mentioned, the state did publish some updated guidance last Friday on February 4th. And that was really kind of some tinkering with and making some slight modifications to its previous guidance from January 14th, which really is kind of like the main sort of framework for what you look at for quarantine and isolation requirements. So again, those requirements, quarantine is what applies when somebody has been exposed to a person with COVID-19, and isolation is what applies to people who have either confirmed or suspected cases of COVID-19, either from a positive test or from symptoms. So the February 4th guidance really retains most of that basic framework from January 14th for most circumstances. And it incorporates all of that January 14th guidance that remains unchanged. So you don't need to refer back and forth to the January 14th guidance and then the February 4th guidance. All of it is just in the February 4th guidance. But there are three main areas where the new guidance does have some changes. I'll talk about each of those in turn, but those three areas basically are for what's called ongoing exposure as it relates to quarantine, some new nuances for whether students, teachers, and staff can participate in before and after school care programs and child care programs, and for travel. Next slide, please. So before getting into the February 4th changes, I thought it would be helpful just to do a really brief overview or recap of the January 14th guidance, because as I mentioned, this is kind of the core guidance that remains in place. I know we've already done a more detailed presentation on this, and this is just kind of the basics. So when it comes to quarantine, the main question is, are you up to date or are you not up to date when it comes to your vaccination? Up to date means that you've received all of the CDC's recommended vaccine doses. So that's the primary course of either a 2-course vaccine or just the single course, including boosters if you're eligible for them, and additional primary shots for immunocompromised people. If you're in this group, if you're fully up to date, you're not required to quarantine following exposure to somebody with COVID-19. Should note that you're also not required to quarantine if you are confirmed to have had a positive case of COVID within the last 90 days. The other main group there, if you're not fully up to date with your vaccination, that means that you're eligible for a booster. It either means that you're not vaccinated at all, meaning you never got the first primary dose, or if you did and you're eligible for a booster, but you haven't yet gotten the booster, then you're considered to be not up to date. And if you're exposed to somebody who has COVID before you get fully up to date, you generally have to quarantine for 5 days. One other group of people on quarantine that's not listed here is that children under 2 and people who are not able to wear a well-fitting mask still have to quarantine for a full 10 days after exposure. And then when it comes to isolation, the January 14th guidance generally provides for 5 days of isolation after either a confirmed COVID test or the development of symptoms. And you can stop isolation after 5 days if you're fever-free for 24 hours without the use of medication, and if your other symptoms have improved. So all of that is still the basic framework that continues into the February 4th guidance. But let's go into the 3 areas where the February 4th guidance provides some changes. Next slide, please. So the first one is called ongoing exposure. And ongoing exposure is when you need to quarantine, but you can't separate yourself from the infected person. And that usually means that you're in the same household with them and you need to provide care for them. So a couple different ways that this could apply to you. If you're not subject to quarantine, under the previous set of rules that I just mentioned, meaning you're fully up to date on your vaccination, the state actually doesn't provide anything that you must do. It only references the CDC's recommended steps for people in this situation, which are that you need to wear a mask around other people, including the infected person at your house, during the entirety of that person's isolation and for 10 days after it ends. And you should get a test 5 days after your exposure, and again 5 days after the end of the isolation of the infected person who you are in frequent contact with and can't isolate from. Again, those are just recommended steps, and those are people who are fully up to date on vaccination. If you're not fully up to date on vaccination, the state provides actually much more onerous requirements for you, and these are presented as requirements instead of just a reference to what you should be doing. So you must quarantine for the entire isolation period and for 5 days beyond the last day that the infected person is in isolation. So this is likely significantly more than the basic quarantine period, because that person who is in isolation is going to be so for at least 5 days, if not more. And you need to tack on 5 days of your quarantine period to the end of their isolation period. So that's a significant additional period for somebody who has to quarantine. Next slide, please. So the next area that the February 4th revisions focus on is school and childcare. And the main thing that it does is provide some exceptions to the quarantine requirements for people who are not fully vaccinated, or I should say not fully up to date. So this is one area where the guidance parses out the not fully up to date people. So the first group is people who are not fully vaccinated, meaning they haven't even completed the first primary vaccine series. Anybody in that category, and this applies to students, teachers, and staff, can only attend school if that school is participating in a test to stay program. The next group is people who have received their primary course of vaccine, but they haven't received the booster shot, but they're eligible for it. That group can still attend work or school at a K through 12 and eligible childcare programs during their quarantine. If a test to stay program is available, they must participate in it. If there is no test to stay program at the school, they are strongly encouraged to test at days 2 to 3 and again at day 5, though that's not listed as a requirement. Both of those groups do need to continue their quarantine outside of school, and all the other rules that would apply to a quarantine apply to them outside of school as well. Then for both of these groups that are identified here, there's some additional guidance with respect to extracurricular activities and childcare programs. So both of these groups can attend extracurricular activities, but only if they do not involve students from other schools and appropriate mitigation measures are in place. Then for childcare programs, both of these groups can attend regardless of whether the program includes students from multiple schools and whether they are located at school or off-site, again, as long as appropriate mitigation measures are in place. Next slide, please. Last thing that the February 4th guidance really touches on is travel. So for people who do not have to quarantine because they're fully up to date on their vaccines, this is, again, kind of recommended guidance instead of requirements. It says that they should test after day 5 after the exposure, and then only travel if negative and symptom-free. Of course, if the tests were positive or if they had symptoms, they should be following the isolation protocols. Wear a mask around others for the entire 10 days. That's the same as any quarantine requirement. But if the person is unable to wear a mask, they should not travel for 10 days following the exposure. For people who do have to quarantine, as in they're not fully up to date on their vaccine, they should not travel during the 5-day quarantine. They should test at day 5 after the exposure. And actually, it does not say that they should test. They must test at day 5 after the exposure. It's not clear whether that was an intentional omission of the word should or not, but in any event, it's not there. And then, of course, only travel if the test is negative and they're symptom-free. If a test is not available, they're not to travel for 10 days following the exposure. And again, same thing about masks, wear them for 10 days following the exposure. If you can't wear one, then you shouldn't travel at all for 10 days following the exposure. And then there's some new guidance around people who are in isolation. It says not to travel for 10 days following symptoms or a positive test. Next slide, please. So I know all of that is quite a bit of sort of granular information to be throwing at you. The state really has drawn a lot of sort of minute distinctions for some of these. So here are the links to the appropriate guidance documents. The first one is the main guidance on isolation and quarantine. It has all of the detailed rules for the situations, how long isolation or quarantine needs to be, and what steps need to be taken in isolation or quarantine. So I would certainly recommend looking at that if you find yourself in any of those situations. The next link is for a table that the state has published to try to make it easier to figure out where you fall in all of these different categories. And I found it pretty useful too as a starting point. It's sort of a grid. So I would say definitely check that out if you find yourself wondering about any of these questions.
Peter, thank you very much. That was a great job. I think you distilled it down very nicely in a helpful way. Folks, these slides will be available on our website. We publish them every week along with the recording of the presentation, so you'll be able to get those links. I echo what Peter says on the tables. I think those are probably the most helpful resource that's out there as you have to deal with these issues on a daily basis. You see our contact information and names here. Please feel free to reach out to us if you have any questions or if there's anything we can do to help. In the meantime, be safe and be well. We'll see you next week.